My name is Malia Sturgis, and I need to provide public notice to Kalispell City Council. This is in accordance with the USCS Rules of Civil Procedures, as well as Rule 17 and Rule 20 of the United States Supreme Court. The Constitution of the United States has the overarching requirements that every state must follow. I don't think anyone here will deny that. The states cannot enact their own alternative legislation substituted for the guarantees of the Constitution of the United States. That would mean that the state laws are more powerful than the Constitution. Clause 1 of Amendment 5 to the United States Constitution says, "No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or grand jury." However, the state of Montana has enacted its own alternative legislation that permits the prosecuting attorney or police officer to charge by information, not by indictment, and that is unlawful. An emolument violation is when you pay a public official to break the law. The Constitution has two areas that enforce this. One is Article 1, Section 10, where it says that no state shall create any law that shall impair the obligation of contracts. Police officers, prosecutors, judges are all under contract, a contract to perform that's based on the oath or affirmation that they took. The contract parameters are defined within the Constitution of the United States. When the state enacts a law that directs their agents to disobey the law, the Constitution of the United States, that would be a violation of Article 1, Section 10. Now, the 14th Amendment is also the other place that you will find the reinforcement of this issue, and that is where it says that no state shall create or enforce any law that shall abridge the privileges or immunities of United States citizens. The privileges and immunities of the United States are at a minimum those enumerated within the Bill of Rights and the first 10 amendments. They cannot be impaired unless the state of Montana has enacted in its inferior constitution that is permitting public officials and law enforcement, whom you all pay, to violate the Constitution of the United States. As a result, there is an inordinate amount of people currently imprisoned in the state of Montana illegally and unconstitutionally. Tanawa Downing is litigating this issue at the United States Supreme Court, and I am here to notify you that if you continue to pay public officials to break the law, there can be criminal sanctions that would come from that. We don't want to go down that path, but officials must be made aware of that paying people to disobey the law is an emolument violation. It is illegal and it is unconstitutional. So I am asking you, honorable people of Kalispell City Council, to please look at Clause 1 of Amendment 5 and confirm that what I am saying to be true, and then direct your public officials to act in a lawful, constitutional manner consistent with the obligations that are codified in the Constitution of the United States of America. And I do have a notice that I would like to present. Is that?
Just give that to Amy over here.
Thank you. All right. Well, thank you guys, and God bless.
Thank you.
Good afternoon. My name is Carson Russell, and I am one of the many civil rights advocates Ms. Sturgis just mentioned. The reason I'm standing before you now is to urge each one of you to take a serious and personal look at the Fifth Amendment of the United States Constitution and confirm what we're saying to be true. Then ask, are your agents acting lawfully and constitutionally as they are obligated to under their oaths? This is not a small issue. This is a very serious matter. As of now, we've already served notice to the Montana Attorney General and Montana Supreme Court Justices. We are fully prepared to bring these issues to the United States Supreme Court if necessary. What we're dealing with is a prima facie per se crime when public officials rely on an inferior state statute to deprive a person of a constitutional right. That alone constitutes a federal crime. That crime is defined in Title 18 U.S.C. subsection 242. Deprivation of rights under color of law. That law says anyone who under color of law deprives someone of their federally protected rights commits a felony. And because they swore an oath to uphold the Constitution, we don't have to prove intent. The breach alone completes the offense. Their willfulness is established the moment they break the promise made under oath. That's the legal foundation of perjury. Now, why are we here talking to you? We don't want to get anybody in trouble because you fund these officials, your police, are violating due process and holding people unlawfully. You're paying for it. That opens you up to liability under conspiracy law. Under Title 42, if a person has knowledge of these violations, has the power to prevent them and fails to act, they can be held personally responsible. That means city officials, council members, administrators, anyone in the position to intervene can be held to the same. We're delivering formal notice and asking you to correct these violations now before further litigation is necessary. This is the least destructive path forward. We have confirmation from individuals like Kash Patel, FBI, that any state judge or official who violates federal law is subject to arrest. We're asking you, let's fix this together. Let's restore the constitutional order. I'll remain here until this meeting concludes, and I hope you understand the seriousness of what's been brought to your attention today. Thank you.